Hello, welcome everybody to the 3906 webinar on a review of recent developments dealing with liquidated damages. It's a relatively hot topic. I'd say it's a perennial topic, certainly as long as I've been in practice. When I used to hear old war stories about a case called Peake and McKinney, which I don't think we're dealing with today. I'm going to keep fairly strict time as best I can, so if I'm brutal with our speakers, I apologize to them. We're going to have about 10 minutes each, and then after their talk has been given, we'll have a couple of minutes for questions, and then we'll move on to the next speaker, and that will give us a little bit of time at the end for winding up or rounding up. Our first speaker is Marion Smith, who will start off. I'm not going to give an autobiography of everybody. A, you can get it off the website, and B, it wastes time. Marion.
Thank you, Richard. So on a Tuesday morning here, and looking at those who are participating the afternoon and evening elsewhere, on what's going to be a dark and stormy next 24 hours, with a perfect storm in front, as we're told, economic uncertainty, financial freefall, let's have a little blue skies thinking. What if you were in the Ministry of Justice, as it's known, MOJ? What would you do about liquidated damages and the doctrine against penalties? Well, the first thing you'd note is that it's been around for a very long time. It started as an equitable doctrine in the Court of Chancery in the medieval times. Sir Thomas More, he of Henry VIII and Hilary Mantel fame, he's on record as having argued about them. Educated lenders were said to use them, and the doctrine moved from equity into the common law long before they were unified in the 1873 Judicature Act. Firmly established during the 19th century, so having spread from England and Wales into the wider common law jurisdiction countries, concerns grew about the unprincipled approach, judicial creativity. That led to the classic case, Dunlop Pneumatic Tyre Company Limited and the New Garage and Motor Company. Now, if I had to make a guess as to how many case names you took out from your early years of education in university, Dunlop Pneumatic is going to be one of them, perhaps up there with Carlisle and the Carbonic Smoke Ball Company. What that had in Lord Dunedin's famous passage was what we were taught was the authoritative statement on how to determine whether a clause was liquidated damages or a penalty. But it didn't resolve. It gave a principled basis, or the start of a principled approach, but the criticism didn't go away. So what is the justification for the rule against penalties? Liquidated damages, I think we'd all agree, serve a very useful purpose. They reduce risk. They promote business certainty. They give comfort that contractual arrangements will be upheld. There's also some quite good evidence that they rein in outlandish demands at the negotiating stage. Without this doctrine, there would be some extraordinary positions being insisted upon in negotiation. That risk management means you can contingency plan, you can hopefully manage your dispute, you can reduce the costs of litigation. There's no need to incur the costs of a quantum expert or bear the lost opportunity cost excessively of your management being tied up in litigation. The benefits to a state-run litigation system is obvious. They are also, I think we would agree, embodied in the DNA of construction contracts. The standard form construction contracts contain and have contained for decades now liquidated damages provisions. And all I tend to see is the addition of further layers of them. They are also used throughout the energy sector. Take or pay, ship or pay, take and pay, just being examples. Given that backdrop, surely we should be encouraging their use. What is the basis for this doctrine against penalties? Despite some dispute in the Commonwealth, the answer is quite clear in England and Wales. It's public policy. The courts will not enforce a stipulation for punishment for breach of contract. You have to remember in some of the discussion we're going to have that the rule against penalties is a rule for controlling remedies. It's not concerned with the fairness of the primary obligation. It kicks in when it comes to looking at the contractual remedy. It reflects the compensation principle that is fundamental to our approach to damages. A penalty clause overcompensates the innocent party. The courts therefore cannot enforce it. That raises an interesting question concerning what happens if, in fact, penal damages are widely available. It also raises the question, what do we do if the doctrine of good faith is accepted in English law? Do we then still need the law against penalties? So let's go quickly to Cavendish, Parking Eye, McDessie, whatever you call it. Two things it didn't do. It didn't abolish the penalties rule, and it didn't allow the courts the power to judicially modify a penalty clause. Very quickly, why didn't it abolish the rule against penalties? That was described as an audacious argument. It was put as its absolute abolish it across the board or abolish it just for commercial cases. Usual reasons given, it's an unwarranted and unnecessary interference with general freedom and sanctity of contracts. And in commercial cases, parties are generally well equipped to look after their own interests. We also have the Unfair Contract Terms Act 1977 and the Consumer Rights Act 2015. Now, the audacity of the proposition was, of course, in the notion that their lordships could abolish the rule. We all now accept that judges do more than merely declare, but can they go that far? And I think in the current climate, perhaps the limits of their lawmaking powers are seen to be very carefully monitored. Would they do it? No, they wouldn't. They refused abolition unanimously. Why? Equivalent rules subsist in other legal systems. This is not an English law nonsense. It's not an oddity. It's very much in line with the civil law jurisdictions. It's been adopted with modifications across the common law countries. In the mixed jurisdictions, it also finds a clear presence. It is worth noting that in the civil law jurisdictions, it usually comes with a power to modify the contract. Also, the Lordship said the statutory protection doesn't cover the field. It certainly doesn't cover small businesses. And there was some concern also that if you take it away, you're going to let in the Wild West with people writing substantial penalties into their contracts. Many felt that this was a golden opportunity passed away. Others felt it didn't matter. In fact, the new rules mean that there will now be ex facto abolition, if not de jure. The second matter, they wouldn't allow the extension to allow judicial modification. And here there was, in fact, better basis for arguing it because the Court of Appeal in Jobson and Johnson had effectively allowed that. That was held as being wrong. So now you have the relief against forfeiture as probably the only route to achieving a compromise position. We can pick up.
Dear, we seem to have lost your sound, Marion. Do you think our IT people...
Can you hear me now?
Yes, we can.
Great. Perfect thing to move on now and introduce the next speakers. First up will be Johan Ho, who's going to explain what the true test of a penalty clause to be derived from their 7 law lords in McDessie is. 6 years on, let's see how the decision is playing out. David Brynmore Thomas is next, and he will address whether the control applies only where there is a breach of contract. Third topic, Anna Lintner is going to look at how that new test has fared, concentrating on 2 recent decisions. And Ben Alburn will look at the kinds of default the doctrine applies to. Then Juan Lopez will consider how the doctrine applies when you're dealing with partial performance. How is it done? I look forward to hearing in part 1 and in part 2 tomorrow. So I think I pass over now to Johan.
Thank you, Johan.
Thank you. So I'm going to talk about what this case, or rather these cases, decided. And I say these cases because the case of McDessie really was a conjoined appeal. And those appeals on on two completely different ends of the spectrum. We had McDessie, that was a big commercial case involving tens of millions, and we had Parking Eye involving an £85 fine for someone who overstayed in a car park. But the principles that applied were exactly the same. What I will do in the next 10 minutes is to introduce the penalty rule and talk about some of its basic concepts and what the Supreme Court said about it. I'll explain what the Supreme Court held in that case, and I'll briefly then outline the facts in that case and explain how the Supreme Court applied the principles that it elucidated. So turning first to the penalty rule, when I use that phrase, what I mean is the law relating to contractual penalty clauses. And when you read the judgment, the judges are very clear that's exactly what it means when they say the penalty rule. And they made clear that whether a clause is a penalty is a matter of construction. So one applies the usual rules of contractual interpretation. You look at it at the time the contract was made. You assess the character of the clause, not the circumstances in which it's being enforced. It's very tempting sometimes to look and say, it's really unfair. It leads to an amount of money that has to be paid. There's a lot more than what the compensation is, but that's not the right approach. You look at it when the parties agreed the clause, looking at it at that point, was it a penalty? Is it a penalty? Another key plank in understanding this is, as Marion has already adverted, this is a rule of public policy. And the Supreme Court was very clear as to that. They were very candid as to that. They were very clear that this rule interferes with the parties' freedom to contract, and therefore it has to be approached cautiously. What this also means, because it's a rule of public policy and you just assess it at the time when the parties agreed the clause, is that there is no discretion available to a judge. If it's a penalty, it's a penalty. Now, subsequent cases, and my colleagues will talk about that later, we'll see judges trying to soften that a little bit. Because while if you take the rule to its logical conclusion, if a clause is a penalty, then it's wholly unenforceable. But we have seen subsequent authorities trying to sever the different parts of a clause. So what happened in McDessie? What did the Supreme Court decide? The Supreme Court focused for purposes of two issues. First, in what circumstances is the penalty rule engaged? Secondly, what makes a contractual provision penal? So starting with the first, when is the rule engaged? The court was very clear that it does not review the fairness or adequacy of a contractual bargain. And that's a fundamental point of English contract law. Whatever consideration the parties agree, if it was a really silly bargain, a very bad bargain, the courts will not interfere. That was their misfortune. But what the court can interfere with and will interfere with is regulating the remedy for a contractual breach. And this distinction is important because one often hears about primary and secondary obligations, these words being bandied about when we talk about penalties. And this explains why there's that distinction. The primary obligation, what the parties agree is the bargain between them, the courts will not touch. But it's the secondary obligation, there's a breach. What follows from the breach, that is where the penalty clause comes in. Now, very clever lawyers and drafters can find ways to make secondary obligations look like primary obligations and vice versa. And the Supreme Court was very astute to that. So they made very clear it does not matter how the parties pitch it or frame it. The court will always look to the substance and not the form of the clause, what was agreed. Now, moving on to the second issue, what makes a contractual provision penal? The Supreme Court looked at a number of authorities, and the two important ones they highlighted were Clydesdale and Dunlop. Clydesdale looked at the distinction between a valid LD clause and a penalty clause and described a penalty clause as an agreement between the parties, unconscionable and extravagant, and one which no court ought to allow to be enforced. Dunlop set out 4 tests in it, which I shan't go into, they're quite long. But what the Supreme Court said is that the heart of Dunlop, the essential question to ask was whether the clause was unconscionable or extravagant. And And we see those words repeated throughout the authorities and the case law: unconscionable or extravagant. Another thing which the authorities, prior to the Supreme Court stepping in, one of the key themes in it was that a penalty clause had a deterrent purpose. That was one of its hallmarks, inter rorum. And the Supreme Court examined this very carefully and made clear that it wasn't quite as black and white as the authorities made. And the tests in Dunlop had unfortunately taken on the character of being a quasi-statutory code. And that was the wrong approach. And it explained that a liquidated damages clause may be justified by consideration other than to recover compensation for breach. And it turned on whether an innocent party had a legitimate interest in performance extending beyond the prospect of pecuniary compensation flowing directly from the breach in question. But what the law will not allow is a remedy where the adverse impact of which on the defaulter significantly exceeds any legitimate interest for the innocent party. So that clause would go beyond the bounds of what the court considers acceptable. And if you're going to take one thing away from my section of this talk, it is this. The Supreme Court said the true test of whether the impugned provision is whether the impugned provision is a secondary obligation which imposes a detriment on the contract breaker, all out of proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation. And that is the guiding star of the McDessie. So you ask yourself, is this a secondary obligation? If so, does it further a legitimate interest of the innocent party? And if so, is the detriment all out of proportion in the enforcement, in the interest of the enforcement of the primary obligation? Now, in a straightforward case, Dunlop is actually still very useful, and the Supreme Court said so as much. But in more complex cases, one then has to grapple with what is this legitimate interest and whether what the consequences of the clause are so out of proportion to protecting the interests. I then turn finally to the facts in McDessie and Parking Eye very briefly and how the principles were applied. McDessie was a case where Mr. McDessie contracted with Cavendish to sell a controlling stake in a holding company. And there were two clauses in the agreement, 5.1 and 5.6, which stated in large part that if he breached certain restrictive covenants against competing activities, he wouldn't be entitled to receive two final installments of the contract price, and he could be forced to sell his remaining shares to Cavendish at a price excluding the goodwill of the business. And the Supreme Court examined whether these clauses were a penalty clause, and it found that it was valid. Its analysis was very important. It found on a proper characterization that the penalty rule was not engaged at all. So it was, on their analysis, a primary obligation, not a secondary obligation. So one doesn't even go into legitimate interest whether it was out of proportion to their loss. And they found that on a proper analysis, it was really a price adjustment clause, even though its occasion for operation was a breach, and did so by looking at how these clauses belong to a group of clauses that fix the price, the manner in which the price was calculated, and the conditions on which parts of the price were payable. And that reasoning applied to the other clause as well. Turning to Parking Eye, and that was the case I mentioned before, the gentleman who parked in a car park for more than 2 hours and contested the £85 fine and fought it to the Supreme Court. That, the Supreme Court said, did engage the penalty rule. And it then went into what was the legitimate interest in imposing this £85 charge. And it examined the circumstances, why there was a good policy for Parking Eye to charge that in order to have a good flow of cars and so on, and came to the view that while it could have been a penalty clause, or it did engage the rule, on a proper application of the principles, there was a legitimate interest, and £85 was not completely out of proportion in protecting that interest. So that sets me up very well to hand over to my colleague, David Braymore Thomas QC, to tell us more about secondary obligations and ingenious drafting.
He will. We haven't come to questions for you, Johan, because David is. It's important for David to, because he's sitting today, for David to speak now. But I do have a question for you that I will ask you to ponder on while David's talking, and that's this. Take the parking case. Let's say the contract is framed as saying it's 50 pence for the first day and 85 pounds for each succeeding day. Is that two primary obligations? And if it's expressed as £50 per day and a fine of £80 for each succeeding day because you're supposed to leave, is that a penalty? And if so, is the distinction really substantive? Anyway, so we will now go to David.
Richard, thank you very much. Johan and Marion, thank you as well. Johan, thank you for setting out McDessie. And Marion, thank you for teeing up what I hope I'll come to at the end of this a few minutes, which is what the Ministry of Justice might do and might have been, in fact, pointed at doing by the Supreme Court. As Richard's question to Johan just identified, one of the significant issues that I think now comes out of McDessie and the jurisprudence is the nature of the obligation that is being addressed. And I think that sometimes there's a tendency, possibly because of the way in which the rule against penalties is taught at law school, for us to jump to testing the obligation by reference to the parameters in Dunlop without asking, first of all, is this a penalty? It's rather similar to the sort of problem that we have with law students who just jump to an exclusion clause without asking whether the exclusion clause actually covers the breach. But this picks up the theme that Richard picked up and that Johan adverted to. So I really want to go back and emphasize this. In McDessie, the definition of a penalty in the speech of Lord Neuberger and Lord Sumption, or the judgment of Lord Neuberger and Lord Sumption, with whom Lord Carnwath agreed, was where a contract contains an obligation on one party to perform an act, and also performs that he does not perform it, he will pay the other party a specified sum of money. The obligation to pay the specified sum is a secondary obligation, and this is the distinction that Johan emphasized. The initial obligation to perform an act is the primary obligation, and then the obligation to pay a specified sum of money is the secondary obligation. Then that is capable of being a penalty. And then they went on to say, if the contract does not impose expressly or impliedly an obligation to perform the act, but simply provides that if one party does not perform, he will pay the other party a specified sum, the obligation to pay the specified sum is a conditional primary obligation and cannot be a penalty. And I think that is worth remembering and worth focusing on, both for those of our audience who draft contractual contracts and obligations, and those of us who litigate them. Now that reflects Lord Diplock in the SCAP trade, classic form of penalty clause: upon breach of a primary obligation of the contract, a secondary obligation shall arise on the part of the party. That is what a penalty is, as a matter of English law. Now, the justices emphasised that it actually was worth restating that analysis, and partly because, as Marion Smith identified, the jurisdiction is to regulate the remedy for a breach of contract. It's not to regulate the fairness or not of the underlying bargain. The penalty rule regulates the remedies available for breach of a party's primary obligations, not the primary obligations themselves. And that may be Johan's answer to Richard's question, although there's a little gloss on that. And that goes back to the idea that is familiar in Dunlop, that the rule against a penalty is to control matters that are a genuine pre-estimate of loss. where a penalty is a way of punishing the contract breaker rather than compensating the innocent party. Now, so far, so good. But the Supreme Court identified and acknowledged that the application of the penalty rule may depend on how the relevant obligation is framed. It can turn on that, whether it is a conditional primary obligation or a secondary obligation. That becomes relevant because in McDessie, not only was the court invited to abolish the rule against penalties, as was identified both generally and in commercial cases, it was also identified by Michael Bloch for McDessie that the rule against penalties might be extended. Now you might say, well, how does that arise? Two cases which suggest or which test this. The first case in England is the Office of Fair Trading at Abbey National, in which the court was, at first instance, was invited to extend the rule against penalties and refused to do so. But then in Australia, in Andrews and Australia and New Zealand Banking Group, in fact, the High Court of Australia did extend the rule against penalties. And what the Australia High Court did was focus on the effect of the clause rather than breach of the underlying primary obligation. What they said in that judgment was, in general terms, a stipulation prima facie imposes a penalty on a party, the first party. If as a matter of substance, it is collateral to a primary stipulation in favor of a second party. And this collateral stipulation on the failure of the primary stipulation imposes on the first party an additional detriment, the penalty to the detriment of for the benefit of the second party. And it says in that case, the collateral or accessory stipulation is described as being in the nature of a security for and interorum of the satisfaction of the primary stipulation. If compensation can be made to the second party if the prejudice suffered by failure of the primary stipulation, the collateral stipulation, the penalty are enforced only to the extent of that compensation. First party is relieved to that degree from liability. So there you can see the Australian High Court testing by reference to the effect of the secondary obligation. You can see the Australian High Court there addressing matters by reference to the effect, not the underlying test of whether this is a remedy for breach of a primary obligation. And the Supreme Court was invited to follow the Australian High Court in doing that. Now, there was the usual sort of wonderful judicial language. I quote, any decision of the High Court of Australia has strong persuasive force in this court, but we cannot accept that English law should take the same path. Now, there are a few discussions in McDessie as to the history of the rule against penalties, and a discussion for that, of that. But then the final two reasons really go to the fundamental legal characterization and then the commercial effects of the decision of the Australian High Court. And I should say that both the decision of first instance in which the ruling, a matter being a penalty, was rejected by the English High Court, and also Andrews in the Australian High Court, both were effectively consumer finance cases. Andrews is a case about bank charges for bouncing checks, or having checks returned, or exceeding an overdraft limit. And in some ways, you can understand why that might be viewed or treated as a penalty, or in some way controlled by the courts because of the issues that arise on consumer legislation. But what the Supreme Court said was the High Court's redefinition of a penalty, Australian High Court's redefinition of penalty, is with respect difficult to apply to the case to which it's supposed to be directed, namely where there is no breach of contract. Because in that case, that was really falling within the scenario identified by Richard Wilmot-Smith just now, which was there was not a breach of contract. It was not, you will not overdraw, we will not bounce checks. It was charge as a consequence for bouncing checks. And then the other concern, which I think is relevant on this webinar, is it said the High Court's decision didn't address the legal and commercial implications of transferring that rule for controlling remedies for breach of contract to a rule which effectively controls underlying primary obligations. And the Supreme Court said modern contracts contain a very great variety of contingent obligations. Although, for example, take or pay contracts, as Marion Smith identified, are sometimes viewed as liquidated damages, very often they're not. Very often take or pay obligations are analysed as being contingent performance obligations. There are complex contingent obligations in financial instruments, in long-term oil and gas contracts, and elsewhere. And what the Supreme Court said was excuse me. I'm being told that I've seconds left. The potential assimilation of all these clauses imposing penal remedies for breach of contract would represent the expansion of the court's supervisory jurisdiction into a new territory of uncertain boundaries, which has hitherto been treated as wholly governed by mutual agreement. And I think that's the important point, is the expansion of a remedy from a pure breach and remedy for breach, which is how matters are presently regulated, works perfectly well. Expanding that into testing what is the equitable or fair consequence of this particular provision, whilst it might work within consumer contracts, banking contracts, would make English commercial law uncertain in a way that would be undesirable. And the Supreme Court endorsed Lord Justice Hoffman in a case called Else 1982 Limited in Parkland Holdings, where he said that while it's true that the question whether the penalty rule applies may sometimes turn on somewhat formal distinctions, Lord Justice Hoffman, as he was, said this can be justified by the fact the rule being an inroad upon freedom of contract, which is inflexible, ought not to be extended. And then the Supremes added, at least by judicial as opposed to legislative decision-making. So I think maybe the takeaway is the Supreme Court refused to expand the rule against penalties into what might be described as conditional primary obligations rather than obligations that are secondary obligations that arise on breach of a primary obligation. Identified very, very good reasons why that rule should not be expanded, and then threw matters firmly into the lap of the Ministry of Justice. So that's it from me. I confess I am sitting this morning on a matter it's liquidated damages. So
it's not completely from you, David, but there's a little bit more time. Basically, the bit of Lord Hoffman's judgment about, well, we're not going to extend the rule, which seems to be a sort of classic slippery slope business, which the courts get into on various things. If the rule is founded upon a formalistic distinction, which can be dealt with one way or another by drafting, what's the jurisprudential reason for the slippery slope doctrine?
Well, I suppose the slippery slope doctrine would be, for example, to say in a take or pay provision. Take or pay provisions sometimes look penal, but it is that the parties in a commercial contract very clearly want to be able to say, look, this is the way we organize our commercial relationships, and there's a very high degree of complexity there. If the court was to extend its jurisprudence in terms of reviewing a clause like that, I'm sure it would be wonderful for many of us on this call, because in fact what we would then need to do is on every sort of provision like that and the implementation of every sort of provision like that throughout English law commercial contract, we would have to test the fairness or otherwise of that underlying bargain. And I think it is that when that is a breach and its consequence, fair enough, we can deal with that. But going into the complex conditional primary relationships that parties enter into under English law commercial contracts is probably a bit beyond the remit of the English bench, the English bar, or actually what our commercial clients want.
Yes, I understand that. I mean, we do pride ourselves on certainty, but I wonder whether the civil law's rather more flexible approach isn't, in fact, de facto what we do. I have one more question before you go, David. You take an acceleration clause, immediate payment of outstanding amounts in the event of default. Is that a penalty? Can it be, if it is a penalty, can it be drafted so it isn't?
I think, again, if you think about that, it is an acceleration on default. So it is an obligation that arises on default and so is tested by reference to the rule against penalties, or can be, because you have that primary obligation, secondary obligation structure. I think you probably could draft it as a conditional primary obligation. And for example, one of the things that the Supreme Court identified was the consequences, the effect of disrupting that structure when dealing with matters that arise on insolvency, where there are conditional primary obligations that arise on insolvency. And that would be a classic circumstance where a conditional primary obligation to repay arose on an insolvency, so that the employer or contractor was paid or recovered monies in whole rather than simply ranking in the insolvency. So I think you can draft that kind of acceleration so that it's not a penalty, but it needs to be very clear as to what circumstance that obligation arises under, rather than simply any default leading to accelerated repayment and therefore being penal.
Thank you, David. Johan, we're not going to come back to you immediately on the question I asked. So the stress can come later. You can absorb what David said. It's now Anna's turn, and Anna's topic relates to the recent guidance from the courts on the Maddressy test, and she's going to cover the de Havilland aircraft case.
Thank you, Richard. I'm going to look at two recent decisions in which the Maddressy test has been applied and identify some takeaway points from those two decisions. The first is the judgment of Sir Michael Burton and de Havilland Aircraft of Canada Limited and SpiceJet Limited. I should say that this is currently under appeal, so watch this space. This case related to a purchase agreement for 25 aircraft, which SpiceJet had contracted to purchase from de Havilland. The purchase agreement included a failure to pay clause, which provided that if SpiceJet failed to make pre-delivery payments under the contract, so that's the primary obligation, and de Havilland terminated as a result, de Havilland would be entitled to recover from SpiceJet liquidated damages in the amount of $2.5 million per aircraft. The clause expressly provided that SpiceJet agreed that such liquidated damages would not constitute a penalty and were a reasonable and agreed amount of the actual or anticipated damages to be suffered by de Havilland in the event of SpiceJet's breach. SpiceJet paid for and accepted delivery of the first 5 aircraft, but then stopped making their pre-delivery payments and refused to take delivery of the remaining aircraft. So de Havilland, unsurprisingly, served notices terminating the purchase agreement and sought to claim liquidated damages for the remaining aircraft, for the undelivered aircraft totaling $43 million. Both sides applied for summary judgment and strikeout, which gave rise to various issues for the court to determine. But for today's purposes, what's relevant is that SpiceJet contended that de Havilland was not entitled to claim liquidated damages because it said the failure to pay clause in the purchase agreement amounted to an unenforceable penalty. The reason I think this case is interesting is because the court grappled with the question of the role that evidence has to play in determining whether a liquidated damages clause is in fact a penalty. So SpiceJet argued it would be inappropriate for the court to give summary judgment on the issue because more evidence was needed of the factual matrix before the reasonableness of the failure to pay clause could be assessed. So, for example, SpiceJet contended that evidence was needed in relation to the actual loss suffered by de Havilland and in relation to the maximum conceivable loss suffered in respect of each aircraft. The judge rejected this. He gave summary judgment and accepted de Havilland's position, which was that, firstly, no further evidence was required as to the factual matrix at the time the purchase agreement was entered into. The question of whether a damages clause is a penalty falls to be decided as a matter of construction at the time it's agreed. Secondly, no evidence was required as to the actual loss suffered. The whole purpose of the liquidated damages clause is to avoid the expense and time incurred in calculating the actual extent of loss. So to insist on that very calculation being carried out in order to justify the pre-estimate wholly destroyed the point of the clause. And finally, evidence was not required as to whether the liquidated damages sum fell below the highest level of damages that could possibly arise from the breach, because that much was obvious on the face of the contract and on the undisputed facts. So the liquidated damages amount was equivalent to approximately 12.5% of the contractual price of the aircraft. The contractual pre-delivery payments, which SpiceJet had failed to make, the primary obligation, were 10% of the value of the aircraft. So 12.5% as liquidated damages did not seem unreasonable. In addition, any aircraft that had been manufactured already, but which SpiceJet had refused delivery of, would not necessarily be sold. Or if de Havilland could sell them to somebody else, they'd have to spend money on reconfiguring them, etc. And if some of the aircraft hadn't been manufactured, then there would be wasted overheads and the manufacturing slots would have been wasted. And SpiceJet hadn't sought to challenge any of those matters. The takeaway points from this judgment are, firstly, it emphasises the limited role that evidence has to play in many cases in determining whether a liquidated damages clause is a penalty clause. That's not to say that evidence will never have a role, but the court will often be able to decide whether a liquidated damages clause is a penalty clause by looking at the contractual clause itself and the undisputed facts. Secondly, linked to this, the court confirmed there's no reason in principle why summary judgment is inappropriate for determination of whether a clause is an unenforceable penalty clause or not. And finally, SpiceJet had expressly agreed in the failure to pay clause itself that the liquidated damages did not constitute a penalty and were a reasonable assessment of the harm that would be caused by their breach. Where you have an express agreement by substantial commercial legally advised parties that a liquidated damages clause is not a penalty clause, it won't necessarily be determinative because it is, after all, a matter of substance over form. But it's going to be a real uphill battle to convince a court that it should go behind that agreement. Moving on to the second decision, Perm Event Limited and Macon. This was a decision of Mr. Justice Zaccaroli and dealt with the interesting question of whether a term in a settlement agreement was a penalty clause. Perm Event was a company that manufactured roofing products under the name Easy Roof System. Mr. Macon was a former shareholder and director who fell out with the company over who owned the intellectual property in the Easy Roof System. Eventually, the parties entered into a settlement agreement to compromise their dispute, pursuant to which, amongst other things, it was agreed that Mr. Macon's shares would be purchased for £620,000 and he would be paid a royalty payment of 5% of the sales of the Easy Roof system. In return, Mr. Macon agreed that he would not interfere with Perm Event's IP rights in the Easy Roof system in various ways, including by claiming an interest in their intellectual property. And if Mr. Macon or anyone on his, that was Mr. Macon's primary obligation. If Mr. Macon or anyone on his behalf breached this part of the agreement, then it provided that the royalty payments will be reduced to zero, Mr. Macon would have to repay any royalty payments that had already been made to him. And he'd also have to pay the sum of £616,000, so approximately the amount he'd received for his shares. We'll call this the event of breach clause. And I'm sure many of you will have seen similar clauses which seek to impose a detriment on one party to a settlement agreement in the event they don't observe its terms. In my experience, this most frequently occurs when there is a complete breakdown of trust between the parties and one party doesn't have any faith that the other party can be trusted to stick to the terms of the agreement. After entering into the settlement agreement, Mr. Macon proceeded to do exactly what he had promised he would not do and registered an equitable interest in 5 of the patents that were the subject of the dispute with the UK Intellectual Property Office. When they found out, Perm invoked the event of breach clause, stopped paying the royalty payments, and issued a claim for repayment of the sums they'd already paid Mr. Macon and the £616,000. Mr. Macon contended that the event of breach clause was unenforceable because it amounted to a penalty clause. The judge had no trouble in dismissing this argument. Although the detriment imposed on Mr. Macon by the event of default clause was undoubtedly extremely harsh, it was not extravagant, exorbitant, or unconscionable as being out of all proportion to Perm Vent's protected interest. The interesting points that come out of this judgment are, firstly, there is no reason in principle why a clause in a settlement agreement could not be a penalty clause. And I think somebody in the Q&A mentioned Heritage Travel and Tourism Limited, in which a similar decision was arrived at. However, if you have 2 legally represented parties, I think it's likely to be a hard sell to convince a court that a negotiated term of a settlement agreement is a penalty clause. On the other hand, where you have an opponent that is, for example, acting in person, then it's certainly something that you need to be alive to when you're considering the terms of a settlement agreement. Secondly, this case is a good example of a situation where the interest which the clause seeks to protect is broader than just payment of a sum due under a contract. In this case, the judge was satisfied that Perm Vent's interest in preventing Mr. Macon from interfering with its intellectual property rights was wide-reaching. If Mr. Macon challenged Perm Vent's patents over the easy roofing system, that would bring the whole company to a standstill and the whole value of the company could be jeopardized. In this respect, the protected interest was similar to that protected by the restrictive covenants in Cavendish. Where you have cases like this, pure economic questions such as the maximum possible loss caused by breach of the primary obligation are likely to be less important in the assessment of whether the clause is a penalty. And then finally, back to the question of evidence. Perm Vent's evidence was that the reason they had insisted on the event of breach clause being included in the settlement agreement was that Mr. Macon was prone to acting aggressively and confrontationally, and that they had no trust in him to keep to his bargain. Counsel for Mr. Macon contended that the likelihood that Mr. Macon would breach his primary obligations under the settlement agreement was not relevant to the proportionality of the consequences imposed on him for breach. The judge agreed with that proposition, but held that what evidence of Mr. Macon's conduct was relevant to was the assessment at the time the settlement agreement was entered into of the degree of harm that Perm Vent was likely to suffer if Mr. Macon breached the restrictions. The more aggressive Mr. Macon was, the more severe the harm that was likely to be caused by him interfering in Perm Vent's rights. And that was a relevant consideration when assessing proportionality. That's all I wanted to say on those 2 decisions.
Well, it's an interesting case. Mr. Macon obviously decided that his unpleasantness should be immortalized in a court case. I'm wondering how much that case is an illustration of how merit actually seeps into what appears to be an impartial and desiccated judgment. I've got one question, which is a broad one, Anna, of you, and it's this, which is this: is a commercial, legally represented party ever likely to succeed in establishing that a negotiated contractual clause was a penalty?
Well, as Marion alluded to at the beginning, it was argued before the Supreme Court that the penalty rule should be abolished totally in relation to commercial transactions where the parties were of equal bargaining power and acted on skilled legal advice. But that argument was rejected. However, the Supreme Court did say that in a negotiated contract between properly advised parties of comparable bargaining power, the strong presumption should be that the parties themselves were the best judges of what was legitimate in a provision dealing with the consequences of breach. So theoretically, it is possible that a clause could be held to be a penalty clause in a contract between two commercial parties. But it would really have to be a very extreme set of facts, I think, to displace the presumption that the Supreme Court identified. And in reality, that's probably quite unlikely to arise. I think we're much more likely to see successful arguments in relation to penalty clauses run in cases which involve less sophisticated parties.
Thank you, Anna. Now, we're now going to move to Ben, who is, I think, the first one who is joining us not from England. Where are you now, Ben?
I'm in Singapore.
You're in Singapore. Well, the title of your talk, as I understand, is what defaults other than delay does the doctrine of penalties apply to? And we've already touched upon heritage travel, but I suspect not deeply enough. So it's over to you now.
Thank you. Just to focus what I'm going to say, I'm tasked to consider the question or the questions to what defaults other than delay and to what remedies other than liquidated damages for delay does the doctrine against penalties apply? And the answer is simple and can be stated concisely. The penalty doctrine conceivably applies to pretty much any default in respect of which there is a contractual stipulation addressing the consequences of that default. Now, it's important to emphasise at the outset, that's not to suggest that these default clauses are routinely struck down as penalties. The reality, as we've heard a little bit already, is quite the contrary, particularly in the commercial context. But what it does indicate is that as litigators, we may well have to consider the issue of penalties not infrequently, but more importantly, as negotiators and drafters, we must always be mindful of the operation of the doctrine and the breadth of its potential application. Now, it is true that the penalty doctrine or the penalty rule is often applied in respect of liquidated damages clauses, providing for payment or diminution in contract price in the event of a delay in completion. In triple point, that was very much the sort of clause that was being considered by the Supreme Court. But the doctrine or the rule is plainly not restricted to that context. And indeed, many, if not most of the leading cases on the penalty doctrine are concerned with altogether different types of provisions. So in the next few minutes, I'll seek to explore, albeit at a relatively high level, how broad is the compass of the doctrine by reference to some of the leading cases and some of the more recent cases. But I won't come back to the cases that Anna has already dealt with in some detail. I won't give full citations to the cases I refer to, and indeed I won't refer to more than a few by name. They will be set out in a set of PowerPoints that we will circulate after the seminar. First, now moving to the compass of the doctrine. First, not surprisingly, the penalty doctrine can apply to strike-down provisions that not only stipulate liquidated damages for delays in completion of works, but also for the failure to complete the works. The LDs may not, as is typically in the case for delay, stipulate a penalty of a certain amount per day, but rather non-payment of an instalment or similar. So the penalty rule will apply in that context as well. The penalty rule can apply to liquidated damages clauses that stipulate the consequences other than of delay or of non-failure, or other than of failure to complete. Thus, in a case called Blue Water Energy Services, the Technology and Construction Court upheld a series of provisions that stipulated the financial consequences to follow from the resignation or replacement of key personnel. Now, it's important to note here that the continuing participation of those persons had been made a term of the contract. If it hadn't been a term of the contract, as David indicated, there would be a real question as to whether the penalty rule ought to have applied at all. But in that case, there were stipulations that the contractor was to pay, for example, $50,000 or $30,000 or $20,000 in the event of a movement on of a specified officer. And those provisions were held to be subject to the penalty rule, but not to be penalties in the circumstances of the case. Quite obviously, and we've heard some mention of this, the penalty rule applies to clauses providing for the forfeiture of deposits. Thus, a stipulation providing for the forfeit of a reasonable deposit is likely to be upheld, but a stipulation providing for the forfeiture of an extravagant or exorbitant deposit may be voided. To give just an example, there is case law, recent case law that suggests that in residential property sales, forfeiture of a 10% deposit is acceptable, but a 25% deposit, forfeiture of a 25% deposit may well be held to be a penalty and unenforceable. The penalty rule also applies to breaches of restraint of trade. And in some ways, this is actually the archetypal case. It was indeed this type of provision, a restraint of trade provision, that was breached in the seminal case of Dunlop Pneumatic and also in Cavendish and McDessie. In the former case, a manufacturer and supplier sought to impose restrictions on its retailers. There were price ceilings, restrictions on markets that could be sold into, and so on. And in the second case, the Cavendish case, the buyer of a business sought to impose restrictions on the seller to prevent diminution of the goodwill in the business. And then there were typical, or perhaps in the case of Cavendish, not so typical, non-compete type provisions. In each case, it was held that such restrictions were susceptible to being struck down by the penalty doctrine if they were not commercially legitimate. The penalty rule also applies to the consequences of non-compliance with a licence. And that is the essential analysis of the case, the Parking Eye case that Johan took us to. That involved a fee levied for overstaying a 2-hour limit in a parking station. Again, it was considered to be susceptible to being struck down as a penalty, but held not to be a penalty on the facts. The penalty rule can also apply where the consequences of can apply to the consequences of non-payment of rent under a lease, and where those consequences are stipulated in the contract. There is a recent case. It has the sort of public interest that some cases have because it involves a Vivian Westwood store in central London that we've all probably walked past many times and admired, or otherwise the garish haute couture inside it. But in that case, the parties had entered into a lease. They had then entered, somewhat oddly perhaps, into a collateral agreement providing for the payment of a substantially lower rent. But it went on to say that if the lower rent was not paid on time, then the higher rent in the main instrument would become payable retrospectively and prospectively. Now, that was held in the circumstances to be a penalty and unenforceable. Finally, the penalty rule can apply to stipulations in loan agreements and settlement agreements as to the consequences of not meeting a scheduled payment timetable. Such stipulations might involve the application of a much higher default rate of interest on outstanding and future repayments. Now, these sorts of default interest provisions have variously been upheld or avoided, depending on the facts, but in principle, there is nothing objectionable to a creditor becoming entitled to a higher rate of interest in the event of default, because it is said in those situations the debtor's creditworthiness has materially changed and a higher interest rate in default is commercially legitimate. And they also apply or the penalty rule also applies in the context of what are referred to as acceleration provisions, which in broad terms require in the event of default that all outstanding payments become immediately due and payable. Now, David in particular touched on acceleration provisions, so I won't say much more than that. So that is all by way of substance that I was proposing to add to the seminar, to my comments in the seminar. I will just finish again by reiterating the point I made at the start as to the potential scope of the penalty doctrine. It is wide and it may cover almost all, if not in fact all, stipulations for the consequences of breach. And this needs to be borne well in mind by all of us as negotiators, drafters and litigators. But once again, the cases do suggest that the impact of the doctrine is rather less than its potential scope. And in truth, very few cases, very few clauses ultimately are struck down as being penalties. Thank you.
Thank you, Ben. I've got a question which can you ponder on while we're listening to Juan, and it's this. You are in Singapore. The Singapore courts must have been dealing with this similar or identical problems. And I'm wondering if you could give us some tips as to the extent to which, A, what they are, what the courts do, and B, whether you think anything which they say in those cases might permeate over here. Thank you, Ben. That was good. Now we move on to our last speaker, Juan, and he is going to be talking about partial performance and the doctrine of penalties and liquidated damages.
I'm going to speak about EcoWorld in terms of its application for a particular way in which the liquidated damages clause may operate with regard to what was live in that case, a part takeover of works, and the way in which the contended liquidated damages clause would operate in conjunction with other provisions of the contract, including a mechanism for the adjustment down of liquidated damages in order to the part takeover of works that was live in that case. The circumstances of the contract are relatively brief, and given time constraints, I can skip through those fairly quickly. So EcoWorld was a property developer employer. Dobler was a trade contractor and engaged to carry out specific works for design, supply, and installation of glazing works. And those glazing works, which Dobler was contracted to engage with, related to 3 residential blocks. And the contract itself contained, as you might envisage, a trade contract particulars, and secondly, the JCT 2011 construction management trade conditions. Contract price was 8.6 million and due for completion by the 30th of April 2018. Those were the specific works that Dobler was engaged to carry forward with. The contract itself, which touches upon one of the nuances that the court had to engage with in relation to the subject clause, did not contain a provision for works to be carried out or completed within sections, so over phases. But rather, it just dealt with the completion of the works in full by the prescribed completion date. And as it transpired, those works for which Dobler was engaged were not completed by that completion date. The claimant then, in those circumstances, elected to take over the residential blocks in 2 months, circa period of 2 months after the completion date. And EcoWorld then took over, in effect, by doing so, Dobler's unfinished works. So it followed, excluding Dobler from that part of the site. And so in that context, a final account valuation dispute arose between the parties. So that sets the scene, hopefully neatly, in terms of the court's consideration of how the liquidated damages clause operated within that part taking over context. For those who are looking up the judgment, it's clause 2.3.21, which provided for liquidated damages payable for late completion of the works. And in this case, that was at a rate of £20,000 a week. There's also clause 2.3.3, which provides a context to understanding how the liquidated damages clause operated and functioned with respect to this contract, and that permitted the claimant to take over part of the works prior to practical completion of the whole of the works. Note also that there wasn't a contractual provision or mechanism allowing for any reduction in liquidated damages. So it was effectively all or nothing in that context. Again, the headline turns to the actual claim itself, Part 8 claim seeking declaratory relief and damages. And if I could just dip into what was essentially a fourfold component argument from the claimant, effectively setting its stall out this way. First of all, it was alighting upon the fact that there is no contractual right under the contract to take early possession. But the liquidated damages provisions of the contract themselves, seen together, don't contain a mechanism for reducing liquidated damages that you might envisage may reflect a fair outcome to take into account properly the fact of early possession. Thirdly, that the liquidated damages clause was invalid and inoperative, it argued, against McDessie. And so that took it to the fourth component of its argument. There's no entitlement overall to general damages for delay, including substantiated damages, which exceeded the liquidated damages cap. The issues of the case, which were largely centered around the validity and overall enforceability of that liquidated damages clause in the context of part takeover, were then foreseeably whether the liquidated damages clause is penal in character in relation to other provisions, largely the second provisions dealing with the entirety of the works required to be completed, which failed to govern by omission, that not being a complaint of the court, but a fair observation of the totality of the contract, part takeover of the works, and also in the context of that mechanism for adjustment down of liquidated damages to reflect part takeover. There was also in the claim an alternative argument relating to the entitlement to claim general damages in the context of delay. That was a bit of a sideshow in terms of the litigation, but nonetheless an important round off for the court to consider. And then thirdly, parasitic on that second lesser point the court had to grapple with, whether there's an arising entitlement to claim damages in the context of the arising delay, and whether recovery should be limited by any void or unenforceable liquidated damages claim. Now, gratefully, I can skip over the fine fundamentals of McDessie because my previous colleagues have set that out very clearly. And then I can turn to Mr. Justice O'Farrell's view through a very helpful route map, I might add, in terms of understanding the interface of the liquidated damages clause in the context of the part takeover, partial completion of works. First of all, he helpfully resounded what we understand to be the Triton-McDessie principles in terms of interpreting damages clauses, accounting for a series of key fundamental components. I can deal with those at high level. First of all, the natural and ordinary meaning of the clause itself, whether or not in conjunction with that clause, whether or not there are relevant other contractual provisions, the overall purpose of the clause, seen within the context of the contract as a whole, the circumstances that are known to and assumed by the parties at the date of contracting, and then standing back from all of that and understand whether or not the clause operates as contended in conjunction with what might objectively be seen as commercial common sense approach. And what the learned judge found is that the clause itself contemplated rightly a failure to meet, basically, contractual dates for completion of various sections of work, even though it didn't relate to those on its face. It also provided for the contractual date for the whole of the works, of course, but it didn't go further, but in circumstances didn't need to go further to take account of an alternative rate of liquidated damages applicable to a late completion affecting only part of the works. And through the course of the judgment, it was readily apparent that the judge was not fazed by the fact that the contract of itself didn't include a mechanism for the adjustment of the rate of liquidated damages after the claimant had effected part takeover. I don't think that was fact specific either, or didn't pivot on the facts, given that the part takeover occurred only 2 months after the failure of the defendant to complete that phasing of the works. I think it was more of a realistic view taken with regard to the contract as a whole, that didn't pose a fundamental issue for the validity of the liquidated damages clause. So on the whole, the learned judge found that the provisions were found to be clear and certain, or could reasonably be so. He also attributed a natural and ordinary meaning to the clause, meaning that any failure by Dobler, as he found, to achieve a practical completion of the works in timely fashion, meant that the claimant was properly entitled to liquidated damages at the rate that was set out under the contract particulars. And so at the stage at which the partial works were complete and there was a part takeover of the works, it meant that EcoWorld had effectively excluded factually Dobler from part of the site by definition, meaning, again, by definition, Dobler was unable to carry forward with what had been the previous obligation to carry out work in relation to that same part. And in turn, that meant for Dobler that it wasn't entitled to any relief from liquidated damages to reflect the takeover, meaning in turn that the full rate of liquidated damages continue to apply in respect of the reduced scope of outstanding work. And I might also add this as quite a neat takeaway from the judgment. What it meant in the circumstances was that in principle, as the court found, a one rate, effectively, liquidated damages clause, as it was framed, is capable of enforcement, even if there was part completion or part possession, and even if there's no related reduction in the liquidated damages payable. And just to contextualize that key thing, certainly for my army, was the claimant's argument, failed argument, that the use of a one rate liquidated damages clause for late completion of any combination of works in relation to those 3 residential blocks on site did not reflect the reality that the claimant had contended, that different levels of loss would be incurred, or that the claimant had taken over reasonably part of the works in light, or to give rise to effect to, a one rate liquidated damages clause. So wrapping all of that up together, what it meant essentially was the court was content to find against the claimant's position and find that the liquidated damages clause on the facts seen against the contract as a whole was not penal or unenforceable. It wasn't unconscionable or extravagant, applying those McDessie tests. Before the court then found, and this resonates also with Marion's observations in terms of the commercial sense of contracting in a way which gives true effect to the intentions of the parties, that the liquidated damages clause have been fully negotiated by professionals historically, and the court would be slow in that context, of course, to intervene in commercial freedoms. And that's especially so when those commercial freedoms were justifiably governing how the risk of delay in works and the completion of those works would be well managed. There was also the important fact that the claimant held a legitimate interest to enforce primary obligations of the defendant to complete works as a whole, but the delay would likely impact on the work of subsequent trade contractors called wider disruption depletion. It also bore in mind the quantification of damages suffered by the claimant, that they would be arduous, and I might contrast in that context the ease by which one can advance the fixing of liquidated damages payable for late completion of work. Certainly that was a valid observation of the court in that context. And then lastly, the court had regard to the level of damages not being evidenced as being unreasonable or disproportionate to cause any unreasonable loss through the late completion of works. And so in that global context, notwithstanding the court had found that the liquidated damages clause was reasonable, it certainly wasn't penal, and it was ultimately enforceable, it was content to find for the defendant on that aspect, but reject the defendant's alternative argument that had been raised, that even had the clause been penal and void, then general damages nonetheless been limited to the level of liquidated damages by reference to the liquidated damages clause itself. So taking all that together, what I would suggest is that the court, and through a very clear route map provided by the judge, provides one helpful and significant signpost, that within the context of a liquidated damages clause, when one is applying McDessie principles together with the rules that together secure commercial freedoms to formulate clear contractual terms, that they together reflect or are capable of reflecting true functionality of the liquidated damages clause, adding when read in the context of the relevant section clauses with which that liquidated damages clause has effect. And that's a general context, but one which extends, as was shown to be the case in Eco World, to a part completion of works or part takeover context. Richard.
Thank you, Juan. Now, some questions. Ben, I'm going to go with you first and then Johan. Ben, have you had any thoughts on the questions I put you on, how the courts in Singapore look at it?
Richard, as any good lawyer will, I'm going to have to start with a caveat. I'm not in a position, not being a Singapore qualified lawyer, to say all that much about Singapore law, even more so on the hoof. So I'm going to take it at a higher level. In a recent case, a 2020 decision of the Court of Appeal, which is the apex court here in Singapore, the court considered Cavendish and McDessie and the reformulation of the law as to the penalty doctrine in the UK, and expressly declined to follow that reformulation of the law, and instead took what might be regarded as a more conservative view, and took Dunlop Pneumatics to still represent the encapsulation of the law as it stands in Singapore. If it's right to call that a conservative approach, and I'm not sure it is reflective of the approach the Singapore courts, at least the apex court here, has taken on a number of occasions recently, where it has preferred the more traditional approach to legal doctrine, and not looked at the more recent reformulations that we have seen from the House of Lords or the Supreme Court, particularly in relation to contractual matters. So all that textbook university learning that we all did, where Dunlop Pneumatic was treated as in a sense, the be-all and end-all of this, may still be worthwhile if we ever have to litigate matters in Singapore law arbitrations.
Thank you, Ben. Right. Well, Marion, that answer seemed to be a little bit of a shock to me, that if you have partial possession, the whole of the liquidated damages clause remains. Does that seem right to you?
You know where I stand on this. I'm someone who actually wants to change the law. I would like us to introduce the civil law jurisdiction approach and allow, it may have to be an arbitration, it may have to be defined in the contract as to how you do it, but I would like us to move away from this total abolition approach and allow the arbitrator to refix the penalty rate. So I'm not going to get involved in the minutiae of the cases. Let's take the big picture point. Let's, in fact, now allow renegotiation, reframing, refixing, because that, I think, is where you might balance the competing policy interests at the appropriate point.
Yes. Well, it always struck me doing international arbitration that when I did my first one, and I thought, well, allowing the court to renegotiate the bargain between the parties, poo-poo, that's terrible, seems to work quite well. Maybe English law isn't the great thing we crack it up to be.
And when you have a specialist court, as we very much do here with the TCC and the commercial court, with all of that experience, with also a great pool available of expert evidence, and given the test that you're applying, which in effect is to work out what the appropriate level should have been. I know you might necessarily not have to do that, but everyone does do it. Why not? Isn't it the logical next step?
Now, I think, right, there is one question which I'm going to take now, and it's this. On a tender where you cannot negotiate contract terms and just take it or leave it, I think that's called the contract of adhesion, isn't it? What happens to the presumption that a contract is freely negotiated between equals in respect of liquidated damages? Ben, do you have any thoughts on that? Don't forget you're on mute.
I don't have any particularly astute observations in general. I think what we take from the McDessie case and the ones that follow and the focus that Anna drew our attention to looking at the de Havilland case is much turns on each case, on the particular wording and on the factual matrix at the time of contracting. I'd be somewhat loath to make general pronouncements as to the enforceability or otherwise of certain provisions in light of where the law stands at the moment.
Yeah, I tend to agree. I'll just say this, that if you read the cases on liquidated damages and exemption clauses and you go worldwide and look at how other jurisdictions deal with them, it seems to me what's at the bottom of all the doctrines, be it exemption clauses, liquidated damages or otherwise, is the equality of bargaining power. And that was where the shoe pinched in the 19th century. And it seems to me that's where the law either took the good or bad turnings that it did in the 20th century, which has taken us to where we are. Now, we are now just about out of time. I'm going to ask Marion to give us all a takeaway from this before we say goodbye. Marion, do you have a takeaway from this?
Yes.
From this seminar?
Be bold. Whilst we still have the doctrine, and we will have for the foreseeable future, be bold, keep records. You want to know why you've agreed to it. You want to know what interests you're protecting, but constantly monitor, and let's consider whether or not in the next 10 years it is the appropriate moment to revisit such a fundamental principle. That's mine. And thank everybody for turning up.
Yes, it's been we're just, I think people are just starting to turn tired. We're now to 192 and we've just come to our hour. It's just expired. I would, on my own behalf, like to thank all the speakers, Anna, who's now beside me, and those who are now on screen, as well as David, who is not and is arbitrating. And thanks too for the audience and the questions we've had from them, albeit that we haven't had time to come to them all. I think that's all.
And sign up for part 2.
Oh yes, part 2 tomorrow. You will have my old pupil Paul Darling in my chair, and so it's going to be far more interesting than my chairing. And you will enjoy it. Although the panelists, of course, are equally good. Thank you, everybody.